A conflict of interest is a situation in which a person or organization is involved in multiple interests, financial or otherwise, one of which could possibly corrupt the motivation or decision-making of that individual or organization. The presence of a conflict of interest is independent of the occurrence of impropriety. Therefore, a conflict of interest can be discovered and voluntarily diffused before any corruption occurs. A conflict of interest exists if the circumstances are reasonably believed to create a risk that a decision may be unduly influenced by other, secondary interests, and not on whether a particular individual is actually influenced by a secondary interest. A widely used definition is, a conflict of interest is a set of circumstances that creates a risk that professional judgment or actions regarding a primary interest will be unduly influenced by a secondary interest. Primary interest refers to the principal goals of the profession or activity, such as the protection of clients, the health of patients, the integrity of research, and the duties of public office. Secondary interest includes personal benefit and is not limited to only financial gain but also such motives as the desire for professional advancement, or the wish to do favors for family and friends. These secondary interests are not treated as wrong in and of themselves, but become objectionable when they are believed to have greater weight than the primary interests. Conflict of interest rules in the public sphere mainly focus on financial relationships since they are relatively more objective, fungible, and quantifiable, and usually involve the political, legal, and medical fields. Related to the practice of law, judicial disqualification, also referred to as recusal, refers to the act of abstaining from participation in an official action such as a court case, legal proceeding due to a conflict of interest of the presiding court official or administrative officer. Applicable statutes or canons of ethics may provide standards for recusal in a given proceeding or matter, providing that the judge or presiding officer must be free from disabling conflicts of interest makes the fairness of the proceedings less likely to be questioned. In the legal profession, the duty of loyalty owed to a client prohibits an attorney from representing any other party with interests adverse to those of a current client. The few exceptions to this rule require informed written consent from all affected clients, i.e. an ethical wall. In some circumstances, a conflict of interest can never be waived by a client. In perhaps the most common example encountered by the general public, the same firm should not represent both parties in a divorce or child custody matter. Found conflict can lead to denial or disgorgement of legal fees, or in some cases, criminal proceedings. In the United States, a law firm usually cannot represent a client if its interests conflict with those of another client, even if they have separate lawyers within the firm, unless the lawyer is segregated from the rest of the firm for the duration of the conflict. Law firms often employ software in conjunction with the case management and accounting systems in order to meet their duties to monitor their conflict of interest exposure and to assist in obtaining waivers. More generally, conflicts of interest can be defined as any situation in which an individual or corporation is in a position to exploit a professional or official capacity in some way for their personal or corporate benefit. Depending upon the law or rules related to a particular organization, the existence of a conflict of interest may not, in and of itself, be evidence of wrongdoing. In fact, for many professionals, it is virtually impossible to avoid having conflicts of interest from time to time. A conflict of interest can, however, become a legal matter, for example, when an individual tries influencing the outcome of a decision for personal benefit. A director or executive of a corporation will be subject to legal liability if a conflict of interest breaches his or her duty of loyalty. There often is confusion over these two situations. Someone accused of a conflict of interest may deny that a conflict exists because he or she did not act improperly. In fact, a conflict of interest can exist even if there are no improper acts as a result of it. As an example, in the sphere of business and control, according to the Institute of Internal Auditors, conflict of interest is a situation in which an internal auditor, who is in a position of trust, has a competing professional or personal interest. Such competing interests can make it difficult to fulfill his or her duties impartially. A conflict of interest exists even if no unethical or improper act results. A conflict of interest can create an appearance of impropriety that can undermine confidence in the internal auditor, the internal audit activity, and the profession. A conflict of interest could impair an individual's ability to perform his or her duties and responsibilities objectively. An organizational conflict of interest may exist in the same way as described above. For instance, where a corporation provides two types of service to the government and these services conflict. Corporations may develop simple or complex systems to mitigate the perceived risk of a conflict of interest. These risks can be evaluated by a government agency to determine whether the risks create a substantial advantage to the organization in question over its competition, or will decrease the overall competitiveness of the bidding process. Conflict of interest in the healthcare industry. The influence of the pharmaceutical industry on medical research has been a major cause for concern. In 2009, a study found that a number of academic institutions do not have clear guidelines for relationships between institutional review boards and industry. In contrast to this viewpoint, an article and associated editorial in the New England Journal of Medicine in May 2015 emphasized the importance of pharmaceutical industry-physician interactions for the development of novel treatments, and argued that moral outrage over industry malfeasance had unjustifiably led many to overemphasize the problems created by financial conflicts of interest. The article noted that major healthcare organizations such as National Center for Advancing Translational Sciences of the National Institutes of Health, the President's Council of Advisors on Science and Technology, the World Economic Forum, the Gates Foundation, the Wellcome Trust, and the Food and Drug Administration had encouraged greater interactions between physicians and industry in order to bring greater benefits to patients. Types. The following are the most common forms of conflicts of interests. Self-dealing, in which an official who controls an organization causes it to enter into a transaction with the official, or with another organization that benefits the official only. The official is on both sides of the deal. Outside employment, in which the interests of one job conflict with another. Nepotism, in which a spouse, child, or other close relative is employed by an individual, or where goods or services are purchased from a relative or from a firm controlled by a relative. To avoid nepotism in hiring, many employment applications ask if the applicant is related to a current employee of the company. This allows recusal if the employed relative has a role in the hiring process. If this is the case, the relative could then recuse from any hiring decisions. Gifts from friends who also do business with the person receiving the gifts are from individuals or corporations who do business with the organization in which the gift recipient is employed. Such gifts may include non-tangible things of value such as transportation and lodging. Pump and dump, in which a stockbroker who owns a security artificially inflates the price by upgrading it or spreading rumors, sells the security and adds short position, then downgrades the security or spreads negative rumors to push the price down. Other improper acts that are sometimes classified as conflicts of interests may have better classification. For example, accepting bribes can be classified as corruption. Use of government or corporate property or assets for personal use is fraud, and unauthorized distribution of confidential information is a security breach. For these improper acts, there is no conflict. Inherent conflict, COI, is sometimes termed competition of interest rather than conflict, emphasizing a connotation of natural competition between valid interests rather than the classical definition of conflict, which would include by definition including a victim and unfair aggression. Nevertheless, this denotation of conflict of interest is not generally seen.